Hello and welcome to this webinar entitled Unfair Terms in Consumer Contracts with me, Keith Markham. As always, let's begin by having a look at the agenda. So we will begin by looking at the applicable legislation and also a flowchart produced by the relevant regulator, which is the Competition and Markets Authority. So the applicable legislation, as we'll see in a minute, is typically these days the Consumer Rights Act 2015, but we'll also refer to a previous set of rules that have some relevance in terms of some of the cases that we will be discussing. The CMA flowchart is something that we're going to look at throughout this session. We'll sort of work our way through it methodically to highlight the various issues that need to be considered, whether you're acting for a consumer or indeed for a business, and whether you're on the claimant or indeed defendant side of this. Then, in terms of the detail of that flowchart, we will work through its various elements in the following order. We'll look first of all at the fact we have something called a blacklist. Those are things that you are never allowed to include in your T's and C's against the consumer. They will automatically be unfair. So we'll look at what's on that. We'll also see there are one or two applicability issues, but classically it's the fact that we're looking for a contract between a trader and a consumer for these rules to apply. We'll then go on to see that the next thing we think about is what we call the grey list. So as the name suggests, things that are unlikely to be fair, but there's a little bit of doubt with regard to that. And we'll see there's a list of 20 of those things contained in the Consumer Rights Act 2015. And we'll also see that what the Competition and Markets Authority have done is to take that particular list and create what they call groupings of their own, which they use for enforcement purposes. We'll be going through that particular list and looking at the sorts of things you shouldn't be including in your T's and C's, but they're not necessarily automatically going to be unfair. We'll also see that in some cases, there is what we call the core exemption. There are certain types of clause that would fall outside of the scope of these rules, and we'll see what that exemption is and how that works. We'll see that ultimately the expectation is that terms and conditions in this context will be provided to consumers in a transparent fashion and what that means. We'll then see that there is a particularly important fairness test. So having gone through all of the various other hoops, if you like, and gone through all the other stages, we will look at this because this is probably the key test that sits at the heart of it. Assuming that we've got a clause that can be assessed for fairness, how do we do that fairness assessment? What sort of factors do we think about? And so on. And then all of this I'll bring together with one particularly recent case, which ironically involves two barristers suing their clients who refused to pay their fees. There we are. You can draw your own conclusions on that, and you'll see the terms that they came up with and what the court had to say about that at the end of the session. We'll also at the end of the session look briefly at enforcement in this area, which we can't really talk about consumer law at the minute at the days of recording without talking very briefly about the Digital Markets Competition and Consumers Bill, which is likely to become law in 2024. And obviously we'll just look briefly at some of the changes in terms of enforcement introduced by that.